I am Craig Kirchman of Kirchman's Incorporated. We're the attorneys of record who are representing the Free Market Foundation in this challenge. Our role is to largely coordinate and drive the process. We work with a team of advocates made up of Advocate Brassie SC and Greta Engelbrecht, and they will be presenting the case in court together with myself, but they will be doing the actual talking and presentation. My role is to coordinate the process and bring it all together. This case is about job creation and preventing further job losses. We believe it's not debatable that the consequences of this legislation is that it impacts on job creation and employment. That's not debatable. Some debate the extent of that effect, but there can be no doubt that job creation will be encouraged by a successful challenge. The legislation allows terms and conditions of employment which have been agreed to at bargaining council level, which generally speaking is large business together with unions. When it is extended to non-parties, those are parties who either aren't in business yet and are contemplating entering the industry or sector, and those who aren't members of the relevant business associations which are party to the bargaining council. They find themselves facing barriers of entry because the terms and conditions result in employment being too expensive, and they don't have the means to pay those rates. I emphasize that I don't think it's debatable that it impacts on jobs. It's merely the extent which it is. But it's a matter of simple economics. The moment you have any mechanism in place which serves to raise the cost of employment, results in reduced levels of employment. That's as basic an economic principle as one could ever encounter, and it applies equally in this case. Well, that is a mystery to some as to why certain people are opposing it, but it is being opposed by the Minister of Labour and 19 bargaining councils actively opposing. A further 4 bargaining councils wish to make submissions in the event of us being successful on the nature of the relief that should be granted. There are wide-ranging reasons for opposition, which, as I've indicated, we don't fully understand, but from suggestions to it will result in a collapse of collective bargaining, which we dispute, to an argument that it would result in a race to the bottom in respect of terms and conditions of employment, which we also dispute. I believe that it is being opposed by some parties for self-interests. Bargaining councils result in employment for some people, and some people enjoy good jobs at bargaining councils, and they would like to, no, quite frankly, I can speculate and go on, but we don't really understand. The Minister of Labour, for example, is simply resisting a change which would result in her having the ability to apply her mind to whether the extension of the terms and conditions of employment would be to the benefit of the greater economy. Why the Minister would not want that discretion is not fully understood. There has been a suggestion that the concern is that the exercise of her discretion may be challenged and result in many court cases and slow down the process, but that I don't accept, because the fact is that we had it before without that problem. The discretion was always there before the latest Labour Relations Act, which came into effect in 1996, and it makes no sense to us. And if the Minister applies her mind properly to extensions, there can be no basis to challenge that, and business is unlikely to challenge decisions unless there are very good reasons to challenge it and good prospects of success. So we think the Minister's concern in that regard is, with respect to her, misplaced. We're a little disappointed at the reaction that we've received at various levels. Firstly, from unions and Labour in the broader sense. Firstly, they've misunderstood it and concluded that it's a challenge to centralised bargaining, which it's not. And secondly, we're disappointed that they don't fully appreciate that a successful challenge here would result in more employment and more union membership for the benefit of all. So we're disappointed at that level. We are disappointed that business hasn't realized the importance of what we're doing until, I must say, very recently. And in the run-up to this case, certainly since the date was set towards the end of last year, we've noticed big business realizing that they do have a role to play, and we believe that if not before the court case, before we get to the next court, be it the Supreme Court of Appeal or the Constitutional Court, we may see other business representatives seeking to get involved and be heard in the courts because they now realize the importance of what we're trying to do.